Okay, welcome everybody. This is part 3 of the 2014 criminal traffic case 66525, which is the state of Florida versus Doss, which is me. My disclaimer, as always, is I'm not an attorney. I don't practice law. I don't give legal advice. If you want legal advice, seek an attorney and be advised. For the full disclaimer, go to the website www.gregdoss.com, gregdoss.com, and you can contact me directly. The contact information, as you can see, is located at the bottom of your screen. Now, this is the second motions hearing before Judge Conrad, which is this will be on June 19th. And by the way, shout out to everybody taking the time to listen to my story. And by the way, if you like the video, please like it and share it with your friends. Now, most of the interruptions, as I was saying before, is probably more so from the passion of my ignorance to the law and legal procedures in the process up to that point. You know, I spent a lot of time doing some YouTube surfing and get my information from various sources. And many of those sources, in fact, actually none of them had any proof of the way that the traffic situation was supposed to work. But hey, it is what it is. I took the time to apply myself, learn information, and from there I've naturally graduated to a greater understanding. So without any further ado, let's get to the case of State of Florida versus me.
All right, State of Florida versus Sir Greg Doss. Good morning, Mr. Doss. Let me just try to get caught up as to where we are in your pleadings. I have a notice of hearing and notice of special appearance that seems to have been filed on June the 17th. Included in that is a number of paragraphs, 1 through 8, 9, 10, 11, 12, and 14, which are entitled Demand for Dismissal. And paragraph 13, or item 13, is a notice of challenge to statute and motion to intervene. It also looks like you may have brought by this morning a notice of constitutional challenge to the statute and motion to intervene, and that might be what's represented in paragraph 13 of your other motion. So it looks like that may just be a little more information on that one item. Is that correct?
Well, somewhat, my honor, but the record does reflect that I'm here under special appearance. There was a question as to whether or not the challenge to the statute was received beyond this office or to the clerk. So I went and refiled it, which would mean that within 30 days, if the if the attorney general doesn't bring it in, validating that then the case got to go, but at this point we couldn't move anyway. But I just went ahead and did it because they said it didn't receive the stamp from the clerk. So I went to the clerk this morning to make sure there'd be no issue. And now this
are you prepared to go forward on that or not? On that issue?
No, I just received it yesterday.
No, this morning.
This morning.
Okay.
So if she has one within the office, because I have to certify another one to Pam Bondi, that would mean I have to certify my only copy. So possible.
Bondi is the Attorney General, right?
Attorney General.
Of the state.
Yes, sir.
Well, let's do this. Let's go through the ones that we got notice of, which would be the notice of hearing, notice of special appearance, and it's scheduled this morning. And we have item number 1, demand for dismissal and no delegation of authority signed by the Congress of the United States. Didn't I rule on this last time?
No, sir. We said you were going to take a break. We're going to rule on it this time relative to whether or not it was germane only to federal courts.
Yeah, right. We ruled on some of these counts that are in this motion. Maybe
right.
Not all of that.
Those things which were relative to the discovery questions, specific to, I guess, the cause and action.
Let me go back.
Cause of action.
In that argument, it looks like you're arguing pursuant to the United States Constitution, I believe.
And let me say this again. One thing I know I definitely needed to work on at the time, and probably to some degree may even today, but I'm not so bad today, is the allowing them to finish before speaking. That's very important, so you get the entire context.
in Article or 28 United States Code Section 3002 that there is no delegation of authority for this court pursuant to federal law. Is that fair or not?
Well,
fair?
Article 3 is the Constitution, where it states that the judicial power of the United States is vested in one Supreme Court, and such inferior courts as Congress may from time to time ordain and establish. Now, through Title 28, Congress does define courts, which the title doesn't supersede the Constitution. And Article 6 of the Constitution makes that clear, that nothing supersedes that. The issue becomes, one, if this venue is a legitimate court, then show me the proof of that, and everybody has the right to that. Because if it's not, then we might actually be in the wrong venue to even bring an action.
But let's go back to that issue. Is there any other legal grounds? Because these are legal issues. These are not factual issues necessarily. It's a grounds for dismissal. And you're arguing legally that this court does not have jurisdiction based on what you believe federal law states.
I would think factually, because I've actually asked the court to produce the authority for the 13th Judicial Circuit to exist. And if they can't produce it, then it's to be construed that they don't have it, because that's also a jurisdictional issue.
Okay. All right. So you want to have any response to that or not? Okay. And again,
her refusal, her not responding is not an indication that I've caught him on anything that matters or anything of significance. We've all probably heard plenty of stories about courts and their ability to exist. He's going to go through a professorial and probably 6th through senior year of high school civics lesson along the way. I would say this: I don't have any proof based upon my experiences that a lot of this stuff that I raise at this time even matters, whether it's delegation of authority and all the stuff regarding oaths and who people are even matters. What matters is, was there probable cause for the stop? Was the stop justifiable?